Good morning, this is your Kelso Report for Tuesday, October 16th, and I'm your host, Clark Kelso. Well, the U.S. Supreme Court has granted cert to answer the question of whether Arizona law that requires proof of U.S. citizenship before voting is preempted by the National Voter Registration Act of 1993. We also have today two First Amendment cases from the Ninth Circuit, one involving regulation of commercial billboards, and the other involving regulation of the distribution of the Yellow Pages. Finally, the California Supreme Court has issued a trio of cases involving the question of whether certain laboratory reports are testimonial in nature, thereby triggering the protections of the Confrontation Clause. Well, let's begin with the United States Supreme Court's grant of cert. Back in April of this year, the Ninth Circuit in bank held in Gonzalez v. Arizona that an Arizona statute which required rejection of a federal voter registration form for federal elections absent proof of U.S. citizenship is preempted by virtue of the National Voter Registration Act of 1993. The Supreme Court has now granted review in this case, which should be argued and decided later this term. The National Voter Registration Act on its face seems to allow states to develop their own voter registration forms, so the question for the Supreme Court will be really how broadly to interpret the preemptive sweep of the federal act. Now we have two First Amendment cases from the Ninth Circuit. The power of local government to impose reasonable restrictions upon the size and location of commercial billboards has been reaffirmed for decades. Owners of billboards and the advertisers who would place their messages on billboards have First Amendment rights, of course, but those rights are subject to reasonable time, place, and manner restrictions. In Charles v. City of Los Angeles, the Ninth Circuit considered the constitutionality of a City of Los Angeles ordinance that required a building permit for all temporary signs, other than those containing a political, ideological, or non-commercial message. They applied the ordinance to a sign advertising the television program E! News. Now, the plaintiff in the case wanted simply to lease exterior wall space for the display of temporary signs bearing content related to motion pictures, theatrical productions, television and radio programming, music, books, newspapers, and other works of art. But it proposed to display as the first sign an image composed simply of the logo for the television show E! News and photographs of the show's hosts, Ryan Seacrest and Juliana Rancic. The city responded with a letter that the sign appeared to be strictly commercial in nature and was thus subject to the sign ordinance's permitting requirements. Well, the Ninth Circuit agreed with the city, finding nothing about the sign that even remotely suggested it was non-commercial. And as commercial speech, it was clearly subject to the ordinance's permit requirements. Next, we turn to the Yellow Pages. Now, how many of you still use the paper version of the Yellow Pages? Today, we of course are more likely to let our fingers do the walking on a smartphone or on the internet. Yet every year, tens of millions of copies of Yellow Pages are still delivered. In the city of Seattle, they have imposed substantial conditions and costs on the distribution of Yellow Pages. A 2010 ordinance requires publishers of Yellow Pages directories to obtain permits and pay a fee for each directory distributed in the city. It also establishes an opt-out registry through which residents can decline to receive directories. And the publishers are required by the ordinance to advertise the availability of the opt-out registry on the front covers of the directory. The company that produces the Yellow Pages challenged the validity of the ordinance under the First Amendment. In Dex Media West v. Seattle, the Ninth Circuit concluded that there was enough straight informational content in the Yellow Pages, as distinguished from commercial speech content, so that the content-based discrimination inherent in the ordinance was subject to the dreaded strict scrutiny, a scrutiny which it, of course, did not survive. The Yellow Pages are protected for further distribution. Next, we turn to the California Supreme Court and a series of decisions they issued yesterday. Over the last decade or so, courts around the state and around the United States have struggled with the question of whether the Confrontation Clause requires that a technician who conducted routine tests and wrote a written report describing the results of those tests needed to testify and be subject to cross-examination in order for the written report to be introduced into evidence. The confusion in this area of law is squarely the responsibility of the United States Supreme Court, which in its 2004 decision in Crawford v. Washington overruled a 1980 decision, Ohio v. Roberts, which had held that the Confrontation Clause allowed the admission at trial of an out-of-court statement if it fell within a firmly rooted hearsay exception or had particularized guarantees of trustworthiness. In place of that standard, the court in Crawford created a general rule that the prosecution may not rely on, quote, testimonial, close quote, out-of-court statements, unless the witness is unavailable to testify and the defendant had a prior opportunity for cross-examination. Unfortunately, what constitutes a testimonial statement has been a source of some disagreement within the Supreme Court. In its most recent case on this matter, the 2012 decision in Williams v. Illinois, the court could not even muster a majority opinion, leaving us with a frustrating 4-1-4 split. That brings us to yesterday's trio of opinions from the California Supreme Court. People v. Lopez, the lead case, and two follow-ons, People v. Dungo and People v. Rutterschmidt. Each of the cases involved the constitutionality of a prosecution expert's testimony about certain information in a report prepared by someone who did not testify at trial. In Lopez, the prosecution at trial introduced into evidence a lab analyst's report on the percentage of alcohol in a blood sample taken from the defendant 2 hours after an accident in which the victim died. The analyst did not testify, but a colleague did. A jury found the defendant guilty. The Court of Appeal reversed, holding that the admission of the non-testifying analyst's lab report and the colleague's testimony violated the defendant's right to confront and cross-examine the report's author. Well, the Supreme Court of California reversed the Court of Appeal, concluding that the report was not testimonial under the United States Supreme Court standards because the statements were made in a report that was not subscribed to by any particular formality or solemnity. And in fact, the substantive contents of the report were nothing more than a printout of data from a gas chromatography machine. In the second case, People v. Dungo, a forensic pathologist testifying for the prosecution, described to the jury objective facts about the condition of the victim's body as recorded in an autopsy report and accompanying photographs. Based on those facts, the expert gave his independent opinion that the victim had died of strangulation. Neither the autopsy report, which was prepared by another pathologist who did not testify, nor the photographs were introduced into evidence. The Supreme Court of California concluded that the expert's testimony did not give rise to a right by the defendant to question the preparer of the autopsy report, because the autopsy report's contents were mostly factual descriptions of the condition of the victim's body and were insufficiently formal in nature to be testimonial. Now, I have to say that I think the scales are weighed pretty heavily now in favor of the prosecution and against the defendant. And there seems to be a pretty strong judicial presumption that the sort of technical reports are true and accurate. A presumption that has sometimes proven unjustified when the occasional scandals erupt about law enforcement testing labs. Although it may be inconvenient and expensive to have the analysts who perform the actual tests appear in court, that type of public accountability for testing practices is, to my mind, a good thing. For now, however, convenience and cost appear to have won the day. And that's it for today's Kelso Report. Have a great day in the law.